Hearing the appeal of Caribbean Welding Supplies Limited and the Attorney General of Trinidad and Tobago.
Yes.
My Lords, I appear with Mr. Ramdeen for the appellant. My learned friend, Mr. Pennington Benson, appears for the respondent. The central issue in this appeal is whether the Court of Appeal was wrong to order the appellant to deliver up its property, a Case 210B excavator, to the state. As Lordships know, the appellant contends, first, that the Court of Appeal had no jurisdiction to make that order, and secondly, that it was in any event wrong to do so because the award of damages to my client involved no double recovery. I shall seek to make...
Well, there's a few other objections than that, I would have thought. I mean, they haven't asked for it back.
Yes, my Lord. But those are the two central arguments on which I...
But the fact that they hadn't asked for it back features in your argument of jurisdiction, does it?
It does feature, yes. And both of those propositions are ones which I shall seek to make good simply by reference to what happened in the proceedings before Madam Justice Quinlan-Williams.
Yes, well, the case was pleaded as one of depreciation, a claim for depreciation.
It was, my Lord.
Yes, and if the damages can be justified on that basis, then based on the findings of fact, then you say there is no double, there's no double recovery.
That's right. And I intend
Even if there is, it doesn't matter, does it? There's no cross appeal against the damages, and you can't just go ordering people to give up their property because it'd be a good idea. It might balance out the damages that were awarded.
Well, I respectfully endorse that observation entirely, my Lord.
We better hear you out.
May I first make some preliminary observations about Cook's Cars and also Brandish Goldschmidt, which the Board have asked us to address. Cook's Cars begins at page 476 of the electronic bundle. It was a case about detention of a crane. And your Lordship see from the bottom of page 477 what it was that the plaintiffs claimed in that case. The final paragraph on that page, they claimed the return of the crane or its value and damages. And over the page at the top of 478, the plaintiffs made an application for judgment under Order 14 of the Rules of the Supreme Court for judgment. And such judgment was given by Master Diamond in terms that the plaintiffs do have return of the crane or recover against the defendants its value and damages to be assessed. In the same paragraph, your Lordship see that at a subsequent hearing, Master Clayton simply assessed damages at 150, and the plaintiffs appealed, arguing that the Master ought to have distinguished the value of the crane from the damages, so as to enable the plaintiffs to decide whether to apply for a writ of delivery up. Can I ask your Lordships to turn up, please, the judgment of Lord Justice Diplock, which begins at page 648.
Page what?
What?
648.
Oh, you mean in the?
I'm sorry. In the weeklies, it's page.
No, sorry.
I'm sorry. It's page 648 of the weeklies. It's page.
You mean it's a couple of pages on in the bundle, is it?
Yeah.
Yes. Right.
I've confused myself. I apologise for that.
6648 is 480 in
Yes,
the
it's 480.
bundle.
That's where his judgment begins. The first passage I'd like to draw your Lordship's attention to is electronic bundle, page 481. The second paragraph on that page addresses the remedies available in conversion. The action in conversion is a purely personal action and results in a judgment for pecuniary damages only, judgment for a single sum, of which the measure is generally the value of the chattel at the date of the conversion, together with any consequential damage. But, with great respect to the dictum of Lord Justice Goddard in a previous case, this is not necessarily the same as the measure of damages for detinue. Over the page on page 482 of the bundle, Lord Justice Diplock contrasts the claim in detinue, which is an action for the restitution of the chattel or of its value. In the final sentence of the first full paragraph on that page, Lord Justice Diplock observed that in addition to an order for specific restitution or the chattel, or for payment of its value as assessed, the plaintiff was always entitled to damages for wrongful detention. And in the result, an action detinue may result in a judgment in one of three different forms. Those forms are for the value of the chattel plus damages, for return of the chattel or its value plus damages, or thirdly, for the return of the chattel plus damages.
Which of those is the correct one in this case?
Well, what was ordered in this case, and I'll show that to your lordships, was the third form. Might I ask your lordships please to note on page 483, at the penultimate paragraph on that page, what Lord Justice Diplock said about how the claim had progressed in the case before the Court of Appeal there. In the ordinary way, he observed, where an action goes to trial, the issues of liability, assessment of value and damages are dealt with at the hearing, and final judgment in one or other of the above forms is entered. In the present case, however, proceedings were brought under Order 14, and the plaintiffs obtained from Master Diamond signed final judgment in the terms they set out, that the plaintiff do have return of the mobile crane or recover against the defendant its value and damage to be assessed. No appeal was brought against this judgment. It is a final judgment granting the plaintiff relief in the second form referred to above, and entitling the plaintiff, upon the assessment of the value of the chattel and of the damages for its detention, to select and enforce his appropriate remedies. So what was referred for further determination in that case was assessment of the value of the chattel and assessment of damages. Then over the page, on page 652, Lord Justice Diplock observed that it would have been, he agreed with Lord Justice Pearson, that it was open to the Master Clayton, upon the evidence to conclude that £150 would cover both the value of the chattel and damages. But an order assessing a single sum of money would be justifiable only under a judgment in the first form discussed above, whereas the plaintiff's entitlement to a judgment in the second form discussed above was already raised judicata under the earlier judgment of Master Diamond. Master Clayton had no jurisdiction to deprive the plaintiffs of that, and the consequent options which a judgment in that form secures to a plaintiff. His sole jurisdiction, his duty under Master Diamond's order, was to assess separately both the value of the crane and the damages for its detention, and to certify these two amounts. The materiality of that, my lords, is that we are in a similar situation in the present case, because all that was left for Madam Justice Quinlan Williams to decide on the 1st of June was the quantum of damages. Everything else, as I shall show you, had been decided already and was raised judicata, and there was no jurisdiction in Madam Justice Quinlan Williams or in the Court of Appeal to interfere with that prior decision and order delivery up. Briefly on Brandis Goldschmidt, this case, which I hope your lordships have separately to the electronic bundle, confirms that there is no universal or automatic rule for assessing damages for wrongful detention of a chattel. It was a case about the consignment of copper. The copper in question was delivered up, but the plaintiff sought damages for the loss in its market value during the period of detention. Could I just ask your lordships to note...
Where are we looking?
Page 868, please, my lord.
I don't have 868 in my
I'm sorry. It's
868 in the hard copy.
It's 868 in the hard copy. So that's if...
I'm not sure if it's got...
I don't think I've got a hard copy, sir.
I printed it out myself.
Oh, I see.
I don't think we've received an electronic version of this, so if you refer us to the passage and read it out, thank you.
I'm very sorry, my lords, we should have brought copies. So the key points I just wanted to note.
Oh, right, okay, yes.
And the reference is page 868.
It was an attachment to Caleb's.
Yeah.
Oh, yeah, that's where I copied it from.
Yeah, I can find that.
Yes, I've got it. We have it, thank you.
Thank you, my Lord.
Sorry, give us the page number.
Page, in the report, 868, letter E. There were no particulars of damage pleaded. Nor, Your Lordship see from letter H, the same page, was there any evidence? The witness did not deal anywhere in his affidavit with what would have happened to the detained copper if it had not been detained. Rather, Your Lordship see on the next page, 869, letter E, the plaintiff's claim in that case reduced to a contention that they were entitled to recover as of right under a general rule of law the amount of a fall in the market value of the copper during the period of detention, irrespective of the use which they would actually have made of the copper if it had not been detained. So the submission in that case was that there was an automatic rule of law that a reduction of the market value of detained goods during the period of detention is recoverable, and that was rejected, perhaps unsurprisingly, by Lord Justice Brandon at page 870, D and E as a matter of principle, and also by reference to analysis of the authorities that followed.
Yes, I mean, the key point which Lord Justice Brandon makes is that damages in tort are awarded by way of monetary compensation for a loss actually sustained, and that the measure of damages may vary depending on the circumstances.
The difference with our case is that the plaintiffs did adduce evidence as to what would have happened to the excavator but for the detention, and the judge made unchallenged factual findings which justified an award of compensation, as I shall seek to show. With that,
it wasn't appealed anyway.
I'm sorry, my lord.
Her decision wasn't appealed by the respondent.
No,
They had 42 days to do so, they didn't.
indeed.
They had 14 days after your appeal in order to serve a counter notice, and they didn't do so.
It's a disappointing result if you appeal and the other side doesn't cross appeal, but you end up worse off at the end of the appeal.
We would not dissent from that observation.
The appeal was perhaps, to the Court of Appeal, was perhaps quite an ambitious claim.
With that introduction, may I turn, my lords, to the proceedings before the judge and run through them only briefly. To begin at the beginning with the claim form, it's on page 4 of the electronic bundle. The first head of relief sought was a declaration of entitlement to possession of the excavator. Point 2 over the page on page 5, an order for delivery up. This was a claim expressly to have the excavator back, not for restitution of its value. And then points 3, 4, 5 and 6 were claims for damages put in detention and or conversion, and also in point 6 for trespass to goods. There's a typo, but that's trespass to goods, point 6. And specifically there was a pleaded claim for loss of use damages and for loss of value damages. That's points 4 and 5. The loss of value damages being in the sum of roughly 1.3 million Trinidad and Tobago dollars. The state filed a defence, but the appellant applied to strike out the defence. The notice of application is on pages 19 and 20 of the bundle. Where your lordship see the relief sought by the application, the striking out, and then on page 20, permission for the entry of judgment for the relief sought in the claim form, those reliefs that we've just looked at. The judge's order on the application is at pages 25 and 26. There was a hearing which both the claimant, the appellant and the respondent were represented. And having heard the parties, she made her order, as you see on page 25, striking out the defence, and then points 3, and over the page 4 of her order giving judgment for the appellant. There was an error in the order. You see in paragraph 4 on page 26, judgment is entered for the claimant against this defendant with special damages on a daily basis. That was not the judge's intention to make any award of special damages, and she later corrected the order under the slip rule to remove the reference, observing that everybody understood that the court had not given any decision on the assessment of damages. For your Lordship's note, that's pages 282 to 284. I don't ask you to turn those up.
Well, wouldn't have applied anyway because the equipment had been returned.
Well, perhaps not. And in any event, it's clear that there was, by paragraphs 5 to 8 of her order, directions were given for the assessment of damages.
Well, I mean, Paul was seeking.
Oh, I see. It was from the date of October the 5th, 2015.
Yes,
oh, yeah. Well, that would have been a mistake. Yeah.
Yes. I mean, the difficulty with that claim is that you'd entered into a contract of sale of the crane to someone, and that person had been using it. You delivered the crane to the would-be purchaser who was going to pay instalments, and while in that person's control, the police seized it.
That is why the judge found that the claim for loss of use damages could not possibly succeed.
Yes.
The same factual finding is what entirely justifies the award of damages in the sum of $1.3 million, which she did make.
Well, the key factual finding to justify that is it not that the judge found that the excavator was worthless by the time it was returned?
So,
Which, if true, would make this appeal rather surprising, but there we are.
the order of the 22nd of March, my Lords, was a final order giving judgment for the appellant on the relief sought. This is the prior order. This was not an order that was appealed. And it declared that the appellant was entitled to possession. It ordered delivery up and for damages to be assessed.
Sorry, which page is that?
We're on the 22nd of March order, which is page 25.
So where does it say entitled to possession, sorry?
Well,
What's your point about that, sir?
this is entering judgment for the appellant.
You've got possession of this.
Yeah, but it didn't include a return of the equipment because you didn't need it. You've got it back. And you say you didn't enter judgment for the return of the equipment.
My learned friend observes in his printed case at paragraph 5.3, page 425, that technically the judge entered judgment on the claim and a declaration and order for delivery up were made.
I'm not sure that's true, actually, but it doesn't matter.
It doesn't matter because by that point, if such an order was made, it was academic because the excavator had been returned.
The judge gave permission to enter judgment. You didn't enter judgment for delivery up because you didn't need it.
We had the excavator. That was not in dispute by that point in time. The point I would like to underline is that neither party appealed this order, giving judgment for the appellant on the claim, and the matters that this order decided were res judicata. All that remained, all that was left for the assessment of damages was, unsurprisingly, the assessment of damages. The significance of that.
So what was the judgment given for then? What was the judgment that you were entitled to enter?
Well,
It was.
Presumably those things which you claimed other than damages.
So you were entitled to enter judgment for damages to be assessed, weren't you?
one of the things that we had claimed.
Well, you got it.
Yes. Effectively, this is a judgment on liability.
Yes.
Summary judgment on a judgment after striking out on liability. So all that is left is an assessment of damages.
But I'm just looking at what she was seeking.
Yes.
One was a declaration.
Yes.
You could perhaps slap judgment to that effect. Secondly, it was an order for delivery up, and then it was damages. I'm just wondering what judgment on liability means here.
Well, it was a judgment to the effect that the state had unlawfully detained the excavator. That question was decided in relation to damages. All that was left was quantum. My learned friend's argument, which I have sought, perhaps unnecessarily, to anticipate, is that it's technically arguable that the judge, by allowing the claimant to enter judgment on the claim as pleaded, was giving judgment that the claimant was entitled to a declaration as to entitlement to possession and to an order for delivery up. But
I don't really see it matters. I mean, he voluntarily given back the excavator. If he regretted his decision and wanted it back after all, he'd need to bring a claim to get it back, and he never did.
Well, it doesn't ultimately matter. It doesn't matter. What does
the ball
matter,
was in his court once he'd given it back. If he said, no, actually, I think I've got some claim to this excavator after all, then he needed to bring one.
what matters in my respectful submission is that, insofar as we're concerned with jurisdiction, is that at the assessment of damages, all that was left for Madam Justice Quinlan Williams to determine were damages. And she could not have, the subsequent date of the 1st of June, have reopened the prior proceedings which had been decided.
Well, there's nothing to reopen because there was no claim for the excavator. It had been given back, and the claimant wasn't pursuing a claim, and the defendant hadn't introduced one, saying now he wanted the excavator, which wouldn't have got anywhere anyway because it didn't belong to him.
Quite so, my Lord, with respect. With that procedural introduction, may I address you on the judge's decision? It begins at page 275 of the hearing bundle, of the electronic bundle. Paragraph 7 on page 276 is the first to show you. There.
Sorry for interrupting.
I'm sorry.
I see that the defendant was in fact represented by counsel at this hearing from page 275, and then defendant's submissions at page 276, paragraph 6. Does that mean that the judge just ignored the late submissions that were put in on the 1st of May 2018? And does it mean also that she didn't hear from counsel for the defendant? Defendant's submissions, paragraph 6.
There was no oral hearing.
There was no oral.
So
it was all on paper.
It was all on the papers.
Yeah.
And it has never been suggested by the state, and there was certainly no appeal by the state on the basis that the judge wrongly refused to have regard to the defendant's submissions.
Yeah.
Paragraph 7, the citation of a case from Trinidad approving an extract from Halsbury on the assessment of damages for conversion, and although related to conversion, it refers to principles that are equally applicable to detinue. In actions for conversion, the measure of damages is ordinarily the value of the goods at the date of conversion. There is no universal rule for the assessment of damages in conversion, equally true in detinue.
Yes, but we have that from Bradley's
Indeed.
Goldsmith.
Indeed.
Why is this relevant, this case on conversion?
Well, the key point is that the judge obviously had well in mind, and over the page she refers to the general rule in tort of restitutio in integrum, the need to avoid windfalls, the need for proof of loss and proof of causation. The judge had well in mind basic principles of when damages are recoverable in tort.
This was a claim in detinue, not a claim in conversion.
Indeed. Well, it was.
Well, the judge may have been rather muddled about the rules that apply, but that doesn't actually matter.
It doesn't ultimately matter, my Lord. I agree with that, because what are crucial are the findings she makes on the facts. And these begin at paragraph 8. What was the market value of the first question she asked? And she answers the question by reference to the existence of an agreement for sale, which was entered into 2 days prior to the excavator's unlawful seizure. There's further reference to the agreement for sale at paragraph 11 of the judgment. And may I just, for your Lordship's note, give you the reference to the agreement itself, which was in evidence before the judge. It's page 68 of the bundle. As the judge observed, there was that agreement to sell the excavator for the sum of $1,328,320, which was the precise sum which the claimant had claimed under one of its heads of damage. At paragraph 9, the judge began considering the available heads of damage, beginning with the claim for loss of use. At paragraph 10, there is reference to affidavit evidence about rental income, but also to evidence of the state of the excavator after its wrongful detention. Photographs exhibited to Mr. Bennett's affidavit, and again, just for the board's note, clear copies of those photographs are at pages 133 to 164 of the electronic bundle. There was also quite detailed affidavit evidence from Mr. Bennett as to the
I don't see why any of this matters. We don't need to look at the photographs of the excavator here.
And I don't ask your Lordships to do so. Let me move on to paragraphs 13 and 14, where the judge rejects the claim for loss of use on the facts. And all I ask you to note is the basis upon which she did so. The loss of use claim failed because of the existence of an agreement for the sale of the excavator. That's the agreement for the sale at 1.3 million. Paragraph 14, second sentence, the claimant's evidence, and I interpose that this evidence was unchallenged, is that but for the detenue, the excavator would have been sold. There was no evidence before the court to suggest that the sale was anything else but a done deal. So that's why an awful loss of use would infringe basic principles of compensatory damages.
The reason the excavator was at the quarry where the police found it was because it was there at the instruction of the would-be purchaser.
Yes, my Lord. At paragraph 15, the court notes that the appellant has got the excavator back. The judge was well aware that the appellant had its excavator back, but on her assessment of the evidence, she found that the excavator as returned to the appellant has either no value or a nominal value.
Quite hard to square with paragraph 12, but it doesn't matter at this stage.
That's her unappealed factual finding on unchallenged evidence. Paragraph 16, the learned judge distinguished a local case, Arab Construction, on the basis that, as set out in the final paragraph in this claim before this court, the excavator was being sold when it was detained. The court has therefore determined and is satisfied on the balance of probabilities that the appropriate award of special damages is the value of the excavator at the time that it was detained.
So your position is that, as I understand it, that standing the finding in paragraph 15, that measure of damages is an appropriate measure of damages of the depreciation.
Absolutely.
And therefore no double counting.
No double counting. And one can reason it one of two ways. Either there has been actual damage to this chattel caused by the detention, or, but for the detention, there would have been a sale on the judge's own findings, and for what she held to be its market value, $1.3 million. So that was the loss which, on the unchallenged evidence before the judge, she considered that the appellant had suffered. And against that background, the Court of Appeal's errors are, in my submission, clear. There was no double recovery, but as a prior point, there was no jurisdictional basis, in my submission, for the Court of Appeal to make any order for delivery up in favour of the respondent. But there was nothing in dispute so as possibly to engage the provisions of section 39(2), If my learned friend is right in the contention he makes in his written case, that as a matter of technicality, the judge on the 22nd of March had made an order for delivery up and a declaration as to entitlement to possession, that only confirms my client's position, because that limited the jurisdiction of the judge on the 1st of June.
It's a rather acute point you're making, when the simpler point is that they never asked for the excavator. There's no claim for the excavator before the court. It had been given back voluntarily. It wasn't handed over pursuant to an order. It doesn't matter whether an order was made or not.
The acute point is responsive to how my learned friend puts it, but the basic and more fundamental point is exactly as your lordship has put it to me now. That brings me then to the final point in the appeal, which is costs. If your lordships agree that the Court of Appeal got it wrong in ordering delivery up, it follows that the costs order, which reflects a mistaken view as to the proper outcome of the appeal, needs to be revisited. The appellant made no submissions on costs below, despite being given the opportunity to do so. So I cannot suggest that you should interfere with the costs order unless you are with me on the prior point of substance. But if you are with me on that point of substance, the proper order, as we've submitted at paragraph 14 of our printed case, would reflect that the appellant's appeal on the issue of loss was unsuccessful. There should have been a costs order against my client. We accept that. But it would also reflect the fact that that issue was only one of 5 elements of the underlying claim, on 4 of which the appellant succeeded before Madam Justice Quindon Williams. So it would be wrong in principle for the cost of the Court of Appeal to be assessed at 2/3 of the entirety of the costs below, when those were costs of issues on which the appellant succeeded, and which did not, apart from the matter of delivery up, which the Court of Appeal raised of its own motion, arise on the appeal at all.
When one speaks about 2/3 of the costs below, what is one talking about? The whole litigation, or the preparation of written submissions for the judge's decision?
The whole litigation.
The whole litigation.
The way the Court of Appeal's order worked was simply to apply the rule of 2/3, which is often applied in the Court of Appeal in Trinidad and Tobago, and award the successful party in the appeal 2/3 of the costs that were ordered below, assuming that there was a simple one-way costs order below.
So that includes outlays, expert witnesses, everything?
That would include the costs of everything below.
What is the test that you say the board should apply in reviewing a costs order of the Court of Appeal? It's a discretionary decision. Do you have to say that they have gone outside the range of their discretion?
No, I don't. And the reason I don't is because the Court of Appeal's discretionary decision was necessarily premised upon the Court of Appeal's view as to the result. And the Court of Appeal's view of the result was that we should give the excavator back. If I persuade you that...
Well, hang on a minute. You appealed, having won on the basis that there was a lost sale, and what was given back was an asset which had been depreciated to 0. You appealed, perhaps somewhat inconsistently, and saying that in addition to the depreciation claim, you were entitled to a claim for loss of use, and you failed in that. That's so, isn't it?
I accept that we failed in that.
And that was the
appeal.
But I mean, there was no appeal by the defendant. It was an appeal raised by you to raise that argument.
Indeed.
and you accept that there should be an award of costs against you. So I come back to the point, what is this court's approach to reviewing an award of costs? You're accepting there should be one against you, but what's the test?
I don't have a submission on what the test would be if the discretionary decision were made on the basis of a correct view as to the outcome of the appeal.
None of the costs were incurred on this point on which you're now appealing, because it wasn't argued by anybody, was it, before the Court of Appeal? It wasn't argued by the respondent that they should have the excavator back.
No, it was just a bonus for them.
His own idea when giving judgment.
I still submit that the error in the Court of Appeal's disposal of the appeal opens up the question of discretion for the board. And as a fallback argument, I would say that the exercise of the Court of Appeal's discretion is so plainly wrong to award the respondent 2/3 of everything below, regardless of the substantial success of the appellant below and the narrowness of the points debated on appeal. So plainly wrong as to justify the board in interfering. That is my fallback position.
Of course, you lost at first instance on the loss of use point, but you nonetheless recovered all the costs.
Indeed.
So there's a sort of lack of sauce for the goose and sauce for the gander here, isn't there? I mean, you're saying you should get all the costs below even though you lost on that issue, and that's quite a substantial issue so far as the assessment of damages is concerned. But even though that was the only issue in the Court of Appeal and you lost, you say you should get rather less than, they should be required to pay rather less than 2/3 of the total costs.
The issue on which we lost at first instance was a sufficiently minor issue.
We don't really know that. It takes up quite a bit of time in the judgment.
It was a
Space in the judgment.
claim for over $2 million, wasn't it, or $3 million?
There's got a lot of evidence relating to it.
It was a sufficiently minor issue that the judge awarded us a simple costs order on the prescribed scale without any proportionate reduction.
Do we know that it was because it was a sufficiently minor issue that she awarded the costs on that basis?
Well, no, she
Or
doesn't.
simply on the basis you'd won sufficient, you'd won on the 1.3 million?
I mean, normally you get your costs if you win and recover a substantial amount, even if you ask for more. So, it's surprising that you got costs on that, especially as that the amount you got is the basis for the prescribed costs.
Indeed, the costs were, as Malone Jr. points out, awarded only on the basis of the $1.3 million claim on which we succeeded.
I see. Yes, I see.
So the prescribed costs were calculated on the basis of the sum on which we succeeded.
No, I follow that. Was there an oral hearing in the Court of Appeal?
There was.
Do we have any sense as to what? Oh no, yes, I see.
And the Court of Appeal's judgment does canvass some of the arguments that were made in relation to the delivery up of the excavator, including paragraph 36.
Right, what does it do?
Well, that was when they raised it, and your predecessor.
In response to the point that the Court of Appeal had made, had raised of its own motion.
Yes, I see.
He raised the point that your predecessor raised the point that the other side hadn't actually appealed the judge's order, but that didn't seem to bother them too much.
Yes, so there was argument about it before the Court of Appeal.
And as Lord Leggett has observed, Mr. Randine did raise the very point.
Yes.
There was no appeal on this ground.
Was there any opposition from counsel for the Attorney General? I mean, did they make submissions on this point? I don't think any are recorded in the Court of Appeal's judgment.
I understand from Mr. Ramdeen that no submissions were made on behalf of the state on this point.
Disadvantage there.
Well, nothing really matters. You probably got the transcript if anybody was.
We do have.
If anybody was interested enough to look. So your absence may not be a insuperable barrier.
My Lords, unless I can assist further, those are my submissions on the appeal.
Thank you very much. Yes, Mr. Pennington.
Thank you, my Lords. I will unsurprisingly take this quite quickly. I understand, and probably the thorniest point is the question of the powers of the Court of Appeal under Section 39 and what was and wasn't live issues. I mean, but can I just outline briefly what I say, because I do want to go back into, notwithstanding there wasn't an appeal, the way in which the case was put, because it is important, because it feeds into why the Court of Appeal was concerned about all of this. So I essentially make 4 points. I say, first of all, the judge at first instance erred as she approached the case effectively as one of permanent conversion. She did not look at the case and in fact did not consider the appellant's own written submissions and evidence on depreciation of value. She just did not approach it in that way. And the result is very much, in fact, that the appellant was overcompensated by her orders. That's point 1. Obviously, I'm going to go back and flesh these out briefly. Point 2, I accept, of course, there was no appeal against the judge's approach to compensation. Neither was there an appeal against the finding of fact that the excavator had no value when it, or nominal value when it was handed back. Although, in fact, both of those decisions are plainly wrong. The Court of Appeal, in my respectful submission, this is point 3.
Just before we move on from point B, second
Yes.
point, why no appeal? What reason? What reason was there for not bringing an appeal?
I don't know why an appeal was not brought, but
Can we put it another way then? You can proffer no good reason for not bringing an appeal.
It doesn't really matter if you don't. If you decide you're happy with the judge, with the order against you, the damages you've been ordered to pay, you don't want to argue that it should be reduced, then you don't need to appeal. And if you don't appeal, then you can't get anything out of the appeal if the other side happens to.
well, subject to Section 39, which is the Court of Appeals.
You can't just go around making orders against the appellant because they take a different view of what the judge decided when the respondent hasn't challenged him.
Well,
It would be chaos if we went around like that.
Well, there is a certain amount of chaos. But anyway, the point is, in fact, that is what Section 39 in terms says, subject to the point it must be exercised cautiously and in a reserved manner. But Section 39 absolutely entitles the Court of Appeal to take points that the litigants don't take. That's its purpose.
So this is your third point, yes.
And the Court of Appeal, point 3, was plainly concerned and rightly concerned about the overcompensation. And effectively, it was in a tricky position because, as I'll show, the judge's order did actually grant the appellant twice the amount of money it was entitled to on his own case. But because we hadn't appealed, I think effectively what the Court of Appeal did is we had a choice between, you can't take the nuclear option, it can't take my case for me and run a case that I haven't run. But what effectively the Court of Appeal did using Section 39 is to say, well, all right, if the judge is going to award damages on the basis that there's been a permanent conversion, i.e. you're going to get, the appellant gets the full value of the chattel back, then the only fair counterbalancing order is that we keep the chattel, because we've paid for it, effectively.
Well, they may have thought that in some overall scheme of fairness, but courts can't go around just ordering people to surrender their own property. You hadn't bought they hadn't bought the chattel off you.
Well, yes, and that's why I think I said at the outset that the trickiest point for me is the jurisdiction point in terms of, well, what orders would have been open to the High Court. But can I...
I mean, if they thought the Attorney General of Trinidad was sort of litigant who needed help because he couldn't be expected to think of points for himself, then they might have thought their way to reduce the damages. What they can't do, surely, is just say, well, you can keep the damages, we're going to order you to surrender your own property, which the attorney hasn't asked for, and which anyway he's got no right to, because it belongs to the appellant.
Well, in a sense, your lordship's, possession is 10/10 of the law with chattel, I accept, but actually there was an open question as to who was entitled to the digger. When you say it's their own property, once somebody has been ordered to pay conversionary damages for taking a chattel.
But that applies in conversion, as far as I understand.
That's the basis of the judge's...
But this is a claim in detenue.
Well, it's not a claim, it's a claim in either or alternative, I think, because what happens is at the time...
Puts at the top of her judgment damages for detenue.
Yes, but in fact orders permanent conversion.
That's the bit I'm finding very difficult to understand.
Well, can I just very briefly go through the papers and try and make good that point, and then I will come back at the end to deal with what I accept is the most tricky point. Well, hang on a second, if nobody's asking for it back. And the best I can do, and I may as well fess up now, the best I can do is simply say that Section 39 as a matter of construction extends that far. And I'm afraid that's where I get to. So, point one, incorrect.
Could I just test that? Sorry for interrupting.
Yes.
But if you turned up and said, by the way, we now wish to appeal, or we now wish to put in a counter notice, the application more than likely would have been refused. And so if you have coherence across the law, you have to have coherence as between an application to extend time, as it were, and the judge just jumping in, or the Court of Appeal just jumping in and doing something.
Yes. Well, there is a very... I totally accept, my lord, that there is obviously an important legal policy question about the extent to which the Court of Appeal exercises powers under 39. It may be that your lordships, after hearing where I need to go to, think that this went too far. If that's the decision, that's the decision. But I say not. It's just about within the confines of it. And actually, does less violence to what the judge ordered than would have been the alternative, which would have been to play around with the damages award. Because what the Court of Appeal, what really should have happened in this case is we should have appealed and said they've been ordered twice as many damages, twice as much.
But you couldn't have got the excavator on any view, even if you had appealed, because you voluntarily returned it. Well, you can't say, no, I've had second thoughts. Well, now I'd like somebody else's property. If there was a double recovery, it was a reason for not having awarded the damages. It wasn't a reason for requiring the claimant to give up property to which he was entitled.
Well, if it was entitled, there was an open, undecided, subject to the cute point that is where I've been hoisted by my own petard, as it were, by saying that the judge did decide that did grant the declaration. That comes back to my Lord Hamlin's question, what did the judge decide?
Why does it return on that? Do you say that if it was conversion, if you voluntarily return property that somebody was entitled, belonged to somebody else, you voluntarily returned it, then the judge awards its value, do you say now you can have your property back? Not your property, now you can have his property because you've been ordered to pay damages wrongly. The law doesn't work like that.
Well, the claim form sought a declaration as to who was entitled to possession. So, yes, if the digger is returned, But insofar as that bit of the claim hasn't been decided, it does, I say, remain open to the judge to have said, subject to getting around some procedural difficulties, but it would have remained open for the judge in principle to say, well, hang on a second, if I'm going to award the appellant the full market value of the digger, then perhaps, based on these authorities, they're not entitled to the possession, because the fact is they've been fully compensated.
Entitled to possession doesn't depend on whether you've had damages. It depends on whether the property belongs to you or whether somebody else has got a better title.
Well,
you don't lose your title because you recover damages.
Well, the only other way to reach the just result, as your lordship said, would have been for the Court of Appeal to adjust the damages.
Perhaps.
It may well be that the relief is wrong, even if the decision is right.
Well, there's no evidential basis for them to reduce the damages. Well, because the evidence accepted at first instance was that it had no value, and that it would require expenditure of $500,000 or $600,000 or $700,000 to put it in a position where it may have some value.
Well, it would have had its.
Well, it doesn't say. Value. All they say is it doesn't say it would have had a value of $1 million or something. Does
no, it does. It says it would bring it up to 262. So the evidence before the judge, which is, except I end up at the same tricky place. So therefore, I don't want to spend a long time going through
262.
The prior points. But at 262, this was the evidence
about what it
led by the appellant before the judge at the assessment hearing.
This is Mr. Mohammed's.
Yes, so it may make sense actually just to start. So at the time the claim form is filed, we have the digger. So at that stage, the appellant says, I want 1.3 million, which is the value of the digger. Then, after the pleading's closed, the digger's returned. By the time you come to the assessment hearing, page 27 of the bundle, is the beginning of the claimant's submissions. And at page 30, we've got reference reliance there on the two affidavits. And then the most important part's at page 32, which is paragraph 13. And the claimant's case shifts, because the claimant now says, look, I've got the digger back, and therefore,
paragraph
13 on page 32 of the bundle record, and correctly says, I'm adducing evidence to show the condition of the equipment was found in to be at the time of the return, and evidence of the costs of the repairs to the excavator would be to return it to the position it would have been at the time of the seizure. And we know at the time of the seizure it was worth 1.3 million, because that's a finding of fact.
But there's something slightly artificial here, because it may be functioning as it was at the time of the seizure, but it is a piece of equipment that is 2 years older. And it would be a strange market that didn't reflect the fact that the equipment was a good deal older than it was at the time of the seizure.
But respectfully, my lord, this is the appellant's case. I mean, your lordship may not think that the quality of the evidence is.
They say nothing about the value, the market value, following those repairs.
Well, he does say
it says that it would be returned to the position it would have been at the time of seizure, which so that here on the invoice or estimate rather, you'll be returned to its original saleable condition. That tells you about the physical condition of the excavator. It doesn't tell you anything about the market value of the excavator in 2018 once those repairs have been carried out. And as my lord says, I mean, it's almost certain that there is depreciation in equipment of this sort.
But once a chattel is returned, then the appropriate measure of damages is depreciation in value.
That's the point I'm trying to make.
So paragraph 14 on page 333, that's the claim the appellant's making, and that's the claim before the judge. That's my point. So the judge wrongly...
Oh, I see. This amounts to...
So the judge wrongly approached this as a case of permanent conversion. The defendant's permanently converted to its use, the chattel, and therefore I want its full market value as at the date of detention. And we say, no, that's obviously wrong. It wasn't even the appellant's own case. They got to get the chattel back. Therefore, their case is, you owe me $724,000, because that's the price it costs to get it back up to the position it was in when you took it.
Yeah.
So that's the appellant's case.
I see.
So
I want
your point is that the 1.3 million on the claimant's case was not a claim for depreciation.
Well, and also the judge's finding that it had no or nominal value can't be rationally supported on the evidence, because the best evidence is the fact that if it was brought back up to its pre-detention value, it would have had somewhere around, I accept, maybe a bit less, a couple of years older, blah, 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 but basically it's got to have some significant value, which is no doubt why we're all sat here.
Exactly. Yeah.
But, so the judge makes a mistake, a fairly glaring mistake, pursuant to which the appellant is, as the Court of Appeal puts it, actually receiving double recovery.
But there's no notice of appeal, no counter notice, and also no submission to that effect at all in the written submissions to the Court of Appeal.
No, well, that's why I have to rely on Section 39.
Yeah.
But anyway, all they could do was perhaps alter the damages if they were very generous. Because I come back to the point, they can't go around ordering surrender of property to which somebody else has been found to be entitled, or is entitled, because you've given it to them, even if you were entitled to it.
Yes.
You've given it to them.
Well, nonetheless, still, I'll make that basic point that the Court of Appeal, for what it's worth, even if it's for the purposes of the judgment, is that's what they were getting at. That was their concern, at least. And I do respectfully submit it was a valid concern. Yeah. The judge then, at 276, page 276 of the record.
But paragraph 14, which you've shown us, is pretty stark, of course, but it's not actually evidence. I mean, it's counsel's submission as to what the loss in value of the equipment was, and putting it at $724,000. I mean, I appreciate that's what's said, but there's nothing in evidence that tells us that.
Yeah, well, maybe they should have done even worse. I don't know. But
I can't see they could have done worse.
The judge was, I mean, all of the evidence in this case was a bit flaky. So even the judge's assessment of the value of the excavator, which was tons more than they paid for it, was based on the contract. I mean, they actually bought it for...
Easily have just got an expert to go along and value it for yourself.
I'm not complaining. I'm just saying the judge proceeded on the basis of an imperfect evidential... I'm not complaining about that. I mean, the judge has to do the best that she has to do on the basis of the stuff that the parties put before her. And the best that she... The only rational decision on the basis of the case that was being led by the appellant was you're entitled to $724,000. On no planet are you entitled to 1.3 million.
Well, that was still the claim in the claim form, wasn't it?
That was still the claim in the claim form. That's the fundamental error of the judge. She proceeds on the basis of what is set out in the claim form without taking into account events that have taken place post-closing of the pleadings, and that must necessarily take into account the fact you get the digger back. Unless you do what the Court of Appeal did, which is say, well, look, if you are going to go down that road and truly place the parties in the position they would have been in but for the detention, the appellant would have $1.3 million and they wouldn't have a digger. And that's what the Court of Appeal has done.
Yeah. Well, you haven't cross-appealed here, so asking us to replace the Court of Appeal's order with a lower award of damages, have you?
I have.
So it's either the excavator can be given up to your client, or it can't.
I can't believe I'm here arguing about it. Anyway.
I mean, this leads to all sorts of... Because if the correct award of damages in respect of, as it were, depreciation was $724,000, then the appellants would have been entitled to damages for loss of use. They would have been. So, I mean, we don't know where that would get the damages to. Well, I mean, it might have come to 1.3 million.
It might have come to a little bit.
No, I don't.
But you couldn't, I mean, it couldn't be right that you're given, the appellants are given the funds damages to repair
On the basis
the excavator, but have got no damages for loss of use in the intervening 3 years or so.
No, because my lord, it places them in a position they would have been, but for the detention. Because once they bring it, once they bring it up to the pre-detention quality, it could then be sold for 1.3 million.
But they've lost the hire during that period.
Well, no, because the judge found they would have sold it 2 years ago. So what they've lost is interest on the 1.3 million.
Which they were awarded.
Which they were awarded.
Yes, all right.
And aggravated damages. So the Court of Appeal's got the right... The problem is the Court of... I don't want to impute to the Court of Appeal thought processes that aren't readily apparent from the black letters of the word. But the thing is, the Court of Appeal is in a situation where it plainly realises, because it focuses on this paragraph and extracts it in the judgment and says, listen, this is double recovery. It plainly is alive to these points. There's no rational basis for the judge awarding 1.3 million. It's obviously wrong. The whole approach to damages is obviously wrong. And the best the court can do without actually doing more violence to the judgment, and the whole point of Section 39, as I respectfully accept, is that you can't... It doesn't entitle the Court of Appeal to jump into the shoes of litigants. They have to exercise the powers cautiously and with restraint. And actually the most cautious and most appropriate order is to simply say, well, look, actually, if the judge was going to go down the road of saying you get your full whack for the value of the digger, you can't have the digger as well.
Unfortunately, they seem to have been under a mistake because they thought that the digger was handed over pursuant to some sort of order, which might possibly have made a difference if you revoked that order, but they didn't appreciate that it was actually delivered before the judgment and given voluntarily and not pursuant to any court order.
Well, that's why
which actually stymies their whole approach.
Well, that's why I've led myself into the path of saying that the judge did inferentially when she granted the judgment in default, whatever it is, I'm not quite sure what it is, but whatever it is, and granted judgment on the claim, that she did grant a declaration that the...
it doesn't matter even if she did, because it had already been surrendered voluntarily, the digger, without the need for any court order.
But if there was a declaration that somebody was entitled to something, and then a court later on interfered with the order and said, well, actually, they weren't entitled to it, then that may well be the foundation for something.
I don't see that, because they didn't rely on the declaration to get the digger. They got it back because it had been given to them.
And once you've given it to someone...
And even if it didn't belong to you, even if it belonged to your clients, they gave it to the appellants.
All right. So that brings me, I think... Well, can I just very quickly, nonetheless, turn up the relevant passages in the Court of Appeal's judgment, 331 and 332. So page 330, actually, can we start, please? Page 330, paragraph 35. And this is the essential point. Can it really be right that the appellant is entitled to have the excavator returned to it?
Sorry, which paragraph, sir?
Paragraph 35 of the judgment.
Right, thank you.
I appreciate it's already been returned and therefore creates the problems that have been thrown at me, as it were. But nonetheless, that's the Court of Appeal's concern. Hang on, you can't have everything. And then at paragraph 42, which is on page 332. It's clear from the foregoing authorities that the appellant cannot recover both the value of the chattel and possession of it, since it would be contrary to established remedies, etc., double recovery. Well, sometimes you can actually have both, but you'd have to have pretty good reasons, because otherwise damages alone is an adequate remedy. Then the Court of Appeal cites Section 39 of the, I keep calling it the Court of Appeal Act, it's the Supreme Court of Judicature
Just
Act.
before you move on from that, paragraph 42.
Yes.
There is no declaration anywhere. There's no document with a declaration on it, is there?
No, so the Court of Appeal addresses that in paragraph 41.
41, you mean?
41, yes, 41. And appears to be suggesting that in effect the judge has said that they are entitled to possession of the excavator.
Where they went wrong was right at the start in paragraph 9 when they said that the excavator was returned following the judgment. And that was just wrong. The judge did say that,
Yep.
but if you actually looked at the dates in the judgment, it was actually apparent that it wasn't true.
I had to accept in the SFI that in fact that the chronology is what the chronology is. I didn't try to rely on the mistake, as it were,
No.
tempting though it was. But no, I mean that's and therefore, but it is, I suppose, slightly rough on the basis that if it hadn't been returned, then it probably wouldn't have been ordered to be returned, because the point is, if in other words, if the respondent had just kept hold of the digger, they would have never been ordered to give it back, because on the authorities, once you pay the full value of the chattel that's been taken, you effectively get to keep the chattel. I mean, that's a sort of practical way of expressing it, and that's how Lord Justice Diplock puts it in the Cook's Cars case. Very briefly, because I'm not sure in the end it's
Going to save you.
going to save me, but for completeness and to fully incur my brief fee, what it says is...
What page is that?
So page 482 at the top. I think this is what, to be fair to the Court of Appeal had in mind. Main paragraph, second sentence. A common law, it resulted, this is an action for debt, resulted in a judgment for delivery up of the chattel or payment of its value as assessed, and for payment of damages for its detention, for example, loss of use. This, in effect, gave the defendant an option whether to return the chattel or pay its value. And I think what the Court of Appeal had in mind is, well, look, if the judge has given you the full whack, as it were, the full value of this chattel, 1.3 million, then the respondent, in effect, has paid for it. And the fair and just order that we make under Section 39 is to say, well, that's... give the digger back. And at paragraph 45 of the Court of Appeal's judgment at page 333, this is where the Court of Appeal infers, I suppose, or finds that in fact the judge did declare that the appellant was entitled to possession of the excavator and ordered that it be delivered.
Insofar as is maybe the...
Well, insofar as... but you see, the declaration, I suppose, doesn't... Yes, I mean, it's no longer required, but it's at least in theory technically a floating question as an unresolved relief of who is entitled to the possession. But anyway, in any event, but what the Court of Appeal then says, in effect, sidestepping...
But why would that be an error of law if that declaration was made? They were entitled to possession.
Yeah.
Well, because they already had it, you mean?
Yeah.
Well, I suppose the Court of Appeal is saying, the Court of Appeal's point is this grounds its jurisdiction, it says, in order to get involved, even though this was a
Well, only if it's an error of law. What is an error of law?
It doesn't need an error of law under Section 39, that's what I say, because
Section... The basis on which they were purporting to.
That is the basis on which they purported to intervene, but actually they don't need to. If I need an error of law, the error of law is the judge irrationally failing to decide the case on the appellant's own statement and evidence. But
I mean, there couldn't possibly be an error in law, could there? Because the declaration, if it was made, was made before the assessment of damages.
yes. Well, this is the...
See, your point is that the assessment of damages was too generous.
That's really where the... That's probably would have been the appropriate relief, is for the Court of Appeal to say that the judge ordered double recovery and therefore we want to interfere with the damages award. The difficulty is under Section 39 that looks a little bit like you stepping into the shoes of a litigant, and therefore the Court of Appeal thought, I suspect, the more proportionate and restrained thing to do is to simply say, if we had not given back the digger, then in accordance with Cook's Cars, we wouldn't have to, because we paid for the full value of it, and therefore the appropriate order is that we keep the digger and they keep the damages, because that is in fact and economically and factually a position that they would have been in but for the detention. Because
I wonder whether they would have taken that line if they had known that you'd voluntarily returned it.
Yeah.
Well, I can only...
Anyway, they weren't sitting under a palm tree in Trinidad, they were sitting in the courtroom, so they couldn't just decide that would be a nice thing, you know, to make general fairness between the parties.
No, but at least submission number one is that was what they were trying to do, and that was a lawdy aim, because in fact there was a significant degree, in fact, of overcompensation, whether we appeal the point or not, and the Court of Appeal is entitled to be concerned about that. And then the last point is the scope of powers under Section 39, and I appreciate that. I said at the outset that's probably the trickiest point for me, but the decision is a case called Hannays, H-A-N-N-A-Y-S. It's at page 580. And in this case, I can just very, very quickly run through what happened. The claimant files a claim for damages based on an account, relying on an alleged account in writing of sums owed. An Order 14 application was made for, I think that's probably for summary judgment. That was rejected, and the defendant was granted unconditional leave to defend the claim, so to defend the debt action or damages action. That is, under relevant statute, an unappealable decision. A defence is therefore filed, a reply is filed. The defendant then seeks to strike out the reply. The High Court dismisses that application. That decision is then appealed to the Court of Appeal. Your Lordships will be familiar with the procedural appeals that are enjoyed. And the Court of Appeal upholds the judge and says, no, there's no basis for striking out the reply. However, this claim is so obvious that I'm going to decide it under Section 39, and I'm going to grant judgment on the claim. And the relevant provisions on page 585 within the judgment halfway down the page, Section 39, so far as is relevant in the following terms. On the hearing of an appeal, so not contingent upon the finding of an error of law, but just on the hearing of an appeal.
So whereabouts on 585 is this, sorry?
Sorry, 589 of the
589.
record, which is within the decision, so I'm just...
585.
Sorry?
Oh, I'm sorry.
Sorry.
What page number, sorry?
585, please.
585.
You were just citing Section 39.
Yes.
Yeah.
I'm just going to the terms of it so we can see what it says.
Yeah.
The question in this appeal was, well, was the Court of Appeal entitled to grant effectively summary judgment on the claim, given that the only issue before it was an appeal against a decision not to strike out a reply? And the point is, although you don't, in my submission, need to locate an error of law in order to exercise the powers in Section 39, the Court of Appeal doesn't need to do that. It can confirm, vary, amend, set aside an order, make any such order, and this is the important bit, as the court from whose order the appeal is brought might have made.
I'm sorry, where are you reading?
So 585.
Yes.
And then
from the section itself. Are you
yes, from the section itself. So on the hearing of an appeal,
yes,
from any order of the High Court, in any civil cause or matter, the Court of Appeal shall have the power to confirm, vary, etc., any such order, or make any such order, as the court from whose order the appeal is brought might have made. So it gives very broad powers to the Court of Appeal, and then it's confirmed subsection 2, that the powers of the Court of Appeal under this section may be exercised notwithstanding that no notice of appeal or respondent's notice has been given. So the whole purpose of this provision is allowing the Court of Appeal to get involved and correct things, even if there's no error of law and even if nobody raises it as a point in the appeal. And the purpose, I mean, the policy purpose behind this and one or two other provisions in this Act is to sort of try and get things decided, get the meat of things decided, rather than let it be entirely party-led. Because sometimes busy parties, like Attorney Generals, that are subject to all sorts of litigation, some of it grand, some of it not, they don't always manage to take every point that they should be taking. So, anyway, the long and short of all of this is, for this decision at least, and it's over the page on 585, and it's at...
Just before leaving subsection 2,
yes,
that the powers may be exercised under the section, notwithstanding no notice of appeal or respondent's notice has been given. Does that, to be coherent, also mean that the Court of Appeal shouldn't exercise the powers if, in the circumstances where it wouldn't have granted leave for a notice of appeal or a respondent's notice to be given?
Well, the Court of Appeal would only, well, procedurally, because of timings, Your Lordship means, I think that can't be right, because the whole point of this provision is that somebody...
Presumably there's power to extend time.
No, but the point here is that in order for the Court of Appeal to exercise this power at all, it obviously must think that it's going to adjust the order in a way that gives justice to the case, meets the interests of justice. And it's necessarily the case that one of the parties hasn't raised the point and they're out of time. Necessarily the case, because you're at a hearing. So there's no procedural bar. The whole point of this is forget any procedural problems or defects. If the Court of Appeal is looking at a case and thinks, look, the right answer is X, but everybody's arguing about something else, a familiar feeling sometimes, no doubt, for judges. Right, okay, well, actually, boom, here's the real point. That's the problem. The judge here overcompensated the appellant. I'm not going to go in and change the damages award, but if the judge is going to award damages on the basis that there's been this permanent conversion, which is the only basis on which in reality she must have proceeded, the correcting order, the correct counterbalancing order is, well, we keep the chattel. Now, in this particular case, the board said, well, actually, because there is a limit, there's a jurisdictional limit on section 39(1), the Court of Appeal may make any such order as the court from whose order the appeal is brought might have made. And what the board, in this case said is, well, hang on, the only issue before the judge was whether or not the reply should be struck out. And that was an unappealable. Sorry. The ruling that the defendant had unconditional leave to defend is an unappealable decision, and therefore the judge had no discretion, had no jurisdiction, because it was statutorily barred. Whereas in the instant case, I say, well, actually, even if it was a damages assessment hearing and the only issue before the judge was damages, there's no jurisdictional limit on the judge reigniting the issue as to who is entitled to possession of the digger. So there's no jurisdictional
Is that right?
issue.
How does that work? I mean, you had an order of the judge. She'd made the order, hadn't been appealed.
Well, this comes back to you.
Could she revisit that order?
Well, this comes back to my law. Well, first of all, my opponent, Mr. Rich's point that, well, actually, if I'm going to argue that the High Court inferentially did grant the declaration that we're entitled to possession, then that's res judicata, and therefore, at the damages assessment hearing, there is no jurisdiction for the judge to revisit it. I think that's a point that's being made against me, I think. But alternatively, if the question, as I think my Lord Hamblin said, well, hang on a second, what has judgment been entered on? It's just liability, i.e. the thing was unlawfully detained, then the question as to who is entitled to possession of it is actually, in theory at least, an issue that she wasn't jurisdictionally prevented from re-entertaining.
Well, that's why I prefer the point that there was simply no entitlement to possession on the part of your client, so it would have been a wrong order to make.
Well, that's why I may end up at the same point, but your Lordships may as well have my submissions, at least then your Lordships can put them in the judgment and explain why they might not be right. But that's what I have to say on that point. In terms of costs, there was an invitation to the appellant to file submissions. They didn't, and therefore I say that's the end of that. Obviously, if the appellant succeed here on this point, then it's a question of whether that would have had a material impact on the Court of Appeal's award of costs. And it's very difficult to say because we don't really know apportionment as between the different issues, but given that no party themselves raised the point, and given that at least on the presumably on the case latterly adopted by the appellant, the digger has no value. Whether or not you have to hand it back is a minor point, I suppose, presumably. But anyway, I just say that it's not sufficient to show that the order was plainly wrong or failed to take into account a sufficiently material or relevant consideration.
I mean, just sort of analysing it, if the appeal were to succeed on the first point that the Court of Appeal made a wrong order, then it would be correct that the Court of Appeal made its order for costs on a wrong basis, partly a wrong basis. But your argument is that it would have been bound to make the same order in any event because the appeal was dismissed. Is that right?
Yes, in other words, the error wasn't sufficiently material to
justify interfering with the order.
Yes.
And re-exercising the discretion.
Yes. I don't think it's a plainly wrong case, as my learned friend says, because the point is that the factors are different. If this court overturns the point on possession, then the factors are different, and it's a question of deciding whether those factors realistically would have made any difference. And I say no.
Or could have made a difference.
Could have. Yes, I suppose could have. I suppose that's right. You lost a chance, I suppose, effectively to make the point. Like I may have said plenty already. Very good. Okay. Well, unless there's anything else, I'll leave my submissions there if I may, my Lordship.
Thank you very much.
Thank you.
Yes.
Well, on 3 brief points in reply. First, my learned friend said that the judge erred in treating this as a case of conversion. The answer to that is that she did not. A decision is described as a decision on debt and new damages. But even if she had applied conversion principles, it doesn't matter. The relevant principles for damages and tort are the same. Secondly, my learned friend says it was plainly wrong for the judge to hold that the excavator had no value. That is a contention which was not argued before the judge. It was not appealed to the Court of Appeal. Indeed, the Court of Appeal themselves acknowledged that finding at paragraph 45 and did not disturb it. The suggestion that it was plain that the point was not taken in the notice of objection before the board, it wasn't taken in my learned friend's written case, and it's just not open with respect to my learned friend for him to run it now. He points to what the appellant said in its written submissions before the judge, to the fact that the appellant was entitled to the cost of repairs and to loss of rental. Those submissions, and as my Lord Richards has observed, they were submissions, not evidence, were rejected by the judge in light of the factual findings that she made. And there is no basis, with respect, for your lordships to disturb those factual findings.
But it wasn't just a matter of submissions. I mean, Mr. Nicholas Mohammed's affidavit seemed to suggest that if you spent 720 odd thousand on repairs, you would restore it to its original condition, to original value. Now, I'm maybe a bit sceptical about that, but that was, I think, his evidence. Page 262.
Yes, that was his evidence, but the finding of the judge, having regard to the evidence, and I showed you the paragraph of her judgment,
yes,
the Lord's, where she considered that evidence. Her finding, considering that evidence and the evidence of the state in which the excavator was returned, was that it was no or minimal value, and there's no basis to.
Yes, and certainly Nigel Bennett's affidavit might support the view that it was of very little value when it was returned.
Yes, my Lord.
Although not of so little value that it wasn't worth appealing to this court rather than just handing it back because it was worthless anyway.
Yes.
Well, of course, your lordships have the evidence that an estimate for repairing the excavator was obtained, which suggests an intention on the part of the appellant to attempt to repair it. I haven't troubled your lordships with the photographic evidence of the dire state in which the excavator was found upon delivery back to the appellant.
Well, but we have read the description in Mr. Bennett's affidavit, and it's in a bad state.
Thirdly and finally, my learned friend suggests that there was some outstanding discretionary decision to be made as to whether the appellant should be awarded restitution of the value of the chattel plus damages or delivery up. What the appellant has claimed, as your lordships have seen, was delivery up of the excavator. That claim had been substantially conceded by the state when it returned the excavator on the 21st of February. The Court of Appeal suggested that, and my learned friend has perhaps disavowed this suggestion, that entitlement to delivery up was formally determined by the judge's order of the 22nd of March. If that is right, that decision had been made, those matters were raised judicata, but the order of the 22nd of March was not appealed. In any event, all that was before the judge when she made her decision of the 1st of June was a decision for the assessment of damages. And in making that decision, she had no jurisdiction to make orders for delivery up. In any event, an order of that kind would be wrong because there was plainly no basis on which the respondent could claim the return of the excavator.
So you say this falls foul of section 39(1) as it did in the Hannay case?
Just as in Hannay's, the judge at first instance could not have made an order in the circumstances of the case as it came before her on the 1st of June for delivery up to the respondent, and therefore the Court of Appeal could not either. Unless I can assist your lordships further, those were my submissions in reply.
Thank you very much. Well, the board is very grateful to counsel for presenting their cases in a succinct manner, both in written form and orally. That doesn't always happen before us. And the rather strange circumstances in this particular dispute will now exercise us. The board also thanks those behind counsel who have assisted in the preparation of this appeal and will take time to consider their judgment.